Hello, am I audible to you? Hello, am I audible to you?
Good morning. Yes, I can hear you.
Good morning. And my screen is visible to you?
Yes, it's visible.
Okay. Is there any query from the last topics?
From my side, I don't have any question till now.
Okay. So today we are going to discuss our next topic, which is consideration and legality of object. It is from our second block. We covered our first block in the last few lectures, and it's our second block and first unit. And if I just talk about the whole unit, it's our fifth unit. So the name of this unit is consideration and legality of object. We are talking about the law, basically business law, which we are talking about. So business law is the thing where we just need to do business with all the rules and regulation which are described by our government. And for that things we just need to do some contracts. There are different kinds of contracts. Some are valid, some are invalid, some are legal, some are illegal. And here the most important thing for a particular contract is which we called consideration. What is consideration? Consideration is a thing when we consider something in against of something. That means if I just give you example for it, if I am just saying it that we are going in a particular shop and we are purchasing some t-shirt or some trousers kind of thing, and we give them money, that means in a monetary terms, that monetary term is the consideration. There are two parties, one is selling those t-shirts, one is buying those t-shirts, but against that monetary terms, and that monetary terms is known as consideration. That monetary terms can be replaced by some kind if we are talking about the consideration in a contract. That means if I just said to you that we are doing a contract, but we can consider something else. It's not important that in each and every contract we consider money only. Sometimes we consider different things, that means kinds also. But 99% cases we consider money in the terms for consideration in a particular contract, because here we are studying business law and we are doing business for money and for profits and not for charity purpose. So today we just going to know about the what is consideration, how we can validate it, how we can validate it with a particular contract, how inadequate consideration can be. There are some exceptions also, and it's also a thing that if there is no consideration, then there is no contract. Then if the object of a particular contract, or the if the object of the consideration in a particular contract is lawful, is unlawful, then that contract is also unlawful. There are some agreements, there are some uh, contract in which consideration is against public policy also. So in this topic we are going to discuss our first thing is our contract. What is contract? A contract which is decided by the two parties in a particular for a particular object, in which there is a legality present there and there is a lawful consideration. If we just talk about the Indian Contract Act covers lawful consideration under Section 10. Means you need to aware about the sections of the Contract Act also, and that Contract Act said that Section 10 covers the lawful consideration. Here the term is not the only consideration, but the term is lawful consideration. That means that consideration would be valid and that consideration would be effective for both the parties. If there is inadequate consideration, or we said that the validity of the agreement is not proper, or the agreement is not enforceable by the law, or our consideration is not enforceable by the law, that contract will become void, which we discussed in our last session. What is void contract, what is voidable contract? So basically that contract becomes void. Now, the meaning of consideration, there are n number of definitions present in different books, but the term consideration basically is also said that quid pro quo. It can be asked in a question paper also, that what is consideration. So you can describe it that consideration used in a sense that quid pro quo, which means something in return. Means we are doing a particular contract, and for that contract we need something in return. That's why we are doing it. If we are not getting anything from a particular contract, so there is no purpose of a particular contract. Means we need some kind of benefits, we need some kind of right, interest, profit from the another party. That's why we are doing a particular contract. If we are gonna face any kind of law, or a person is saying that they are not responsible for anything, then why we are doing a contract if we are not getting any kind of profit? So for a particular thing, when we said that we need a profit, we are doing a business, we are doing a contract. In that thing we need some benefits, we need rights, we need profit, and that right, that profit, that benefit is known as consideration. There are so many case studies also who explain the term consideration, but according to Indian Contract Act, because we follow Indian Contract Act for our syllabus, so in fact not for our syllabus, but for a whole business law, we just follow Indian Contract Act. So according to Indian Contract Act, definitions covered under Section 2 subsection D. So basically, when we talk about the definition said that consideration as when the at the desire of the promiser. Here promiser is the person who is doing a contract, who is proposing a contract. The promisee or any other person, promisee is the person who is accepting the contract. Means there is a person who is desiring some kind of proposal, who is a promiser, to the person who is accepting it, that person is promisee. Or any other person has done or abstained from doing, or does or abstain from doing, or promise to do or to abstain from doing something, such act or abstains or promise is called a consideration for a promise. Basically, if in a short term, if we just understand this definition, is saying that we are doing a contract to do something or to not to do something. Means there is both kind of contract, to do a particular work, to execute a particular work, or we do some kind of contract in which we are not gonna perform a particular mm, promise, or we did not follow, we are doing that contract not to do that thing. So in both the things we just need something in consideration. That means we need something in return, that is known as consideration. And always there are two parties, one is promiser and one is promisee. Always remember that promiser is the person who is proposing the contract, and promisee is the person who is accepting the contract. Here are some examples to understand the term consideration. We just gonna I'm gonna read out the first one example. A agreed to sell his business to B for rupees 10 lakh. Here B promise to pay rupees 10 lakh in the consideration for A promise to sell the house. That means here A is agreeing to sell his house to B. First thing is that. But in return, what he want? 10 lakh rupees. Then B promised to pay 10 lakh rupees. That means that become a valid contract. For A promised to sell to sell the house, and A to sell the house in the consideration for B promised to pay 10 lakh rupees. That means both the parties are agree on a same thing, that one is going to sell the house, and one is going to purchase the house. When both the parties are agreeing on the same thing and they both are agree for 10 lakh rupees, that means that is these 10 lakh rupees is the consideration for a particular contract, and I can say that for this contract. So here second example is X promises his debtor. Here debtor means the person who is going to return our money. X promises his debtor Y not to file a suit against him for 1 year on Y agree to pay him rupees 1000 more. Here, absence of X is the consideration for Y promised to pay. That means, according to our definition, what we read that in some contracts, we do a contract with some consideration for not doing particular act. Here, X promises to Y that please don't file case against me, or I'll give you rupees 1000 or more if you not gonna file case against me. That means here person X is going to stop person Y from doing for doing a case on him. That means in this contract here is a consideration for rupees 1000, but here is a contract for not doing a particular thing. In example A, we are paying 10 lakh rupees for doing a particular thing. So if we talk about consideration, it covers both the thing. If a contract of doing a particular act, or if a contract of not doing a particular act, but there is a consideration in it, so that consideration and that contract become a valid contract. There are some more examples you can read out, and there is also a thing that no consideration, that means no contract, is a rule of a law. That means our law said that if you want to do if you want to do a contract, you have to make something for the other party. You have to provide some benefits, you have to provide something to the other party. That is known as consideration. Here are two cases. Cases means in the past there are things happened, so for our study or for our references we note down that particular cases to understand the concept betterly. So here are two cases for you: Abdul Aziz versus Mazum Ali. In this particular case, person verbally promised the secretary of the mosque committee to subscribe rupees 500 for rebuilding a mosque. Later, he declined to pay the said amount, held there was no consideration, hence the agreement was void. In a particular case study, first thing is that agreement, that is not a particular contract, that is just a verbal agreement. In the first lecture we studied about the contract which can be written and which can be oral. Here if we talk about, this is the oral. That means we are just talking about verbal thing. If we are just talking about verbal thing and the other party say no to it, or did not react about it, so that means that becomes void contract. Void, what is void contract? Void agreement when we are able to do, when we promise it, but in the end one party said no to the contract, or one party did not perform the contract or execute the contract, so that contract become void. Their second case study is Kedarnath versus Gori Muhammad. In this case, defendant has agreed to subscribe rupees 100 towards the construction of a town hall at Howrah. That means defendant, the person, agree that time that he wants to construct a town hall at Howrah, and he gives rupees 100. On the faith of the promise, the secretary called for plan, entrusted the work to contract, and undertook liability to pay them. That means a particular person set all the things and he execute the contract. Next, the agreement was enforceable, being one supported by consideration in a form for a detriment to the secretary who had undertaken a liability to the contractor on the faith of the promise made by the defendant. Here, the person who did not pay that money, that person is liable to pay that money because that thing is happened for a particular consideration, and the other party needs to perform the contract or execute the contract because the other party already performed it. So in that cases, you the other party can file the suit against him and pay and recover the compensation from that party. Here are some legal rules for valid consideration, which also covers under section 2 subsection D. When we just talk about the legal rules of a valid consideration, they are just like the valid rules for the legal contract. So our first point is consideration must move at the desire of the promiser. That means the person who is proposing a contract to the other person, that person has a eligibility, or that person has a plus point or a benefit point for him or her, that he can decide the consideration in a particular project because he or she is proposing a contract to the other party. When he or she is proposing that contract, that means that person needs to accept it, or he or she can uh, say no to it. For example, if you go in a shop and you want to buy something, and there is that one is also a kind of contract, you just need to buy that thing, and that company already labeled that product with a price, and it's now your call, you want to take it or you don't want to take it. If you take it, that means you are agreeing for that particular price and you pay for it, you came to your home, that contract is over, or I can say that agreement is over. Both it comes with both the things, agreement or contract, both. So here, if we just talk about the consideration, it is it is a thing that particular person can revalidate it, can change it, and the person who, because that person is proposing a contract to the other person, so he has all the rights to change the consideration, but he cannot change that consideration once he propose the contract. If he changed the price or he changed the consideration after he proposed the contract, that contract or that agreement become void. So the person who is gonna propose the contract need to first decide about the consideration and then execute that promise to the other person. Here is also example: deconstructed a market at the instance at the collector of a district. The occupants of the shop in the said market promised to pay D a commission on articles sold through their shop. Held there was no consideration because the money was not spent by the plaintiff at the request of the defendant but voluntarily for a third person, and thus the contract was void. And it is a case of Durga Prasad versus Baldev. So that means here is a person, when he said that you need to pay commission because you are doing a particular business on that particular place. So you just need to pay commission for that thing. Whatever you sell out, you just need to pay a particular price for it to a third person, which is obviously a void contract, because the person who is selling it, that consideration is only it's only for him or not for someone else. Our next point is consideration may move from the promisee to any other person. So in that case, we are saying that a person who proposed the contract to the other party, that party is a promisee. And here we are saying that consideration move from that person to the other person if the person who is saying yes to the particular contract, he said that you just uh, basically transfer the benefits to the other person. For example, if our for example, I am just taking about the example for a family. If the senior person did any kind of contract or did any kind of basically agreement, and that person said that no, please don't give it to me, give it to my son or give it to my daughter. So in that case, that consideration shifts to his son or to his daughter. That means that consideration shift from the promisee to the other person, but that happen only when the promisee willing to do that. If promisee not willing to do that, that is not gonna be happen. So here what we learn from this point, that a consideration can move from promisee to the other person. Our next point is consideration may be past, present, future. Means consideration can be happen in the past, can be happen in the present, and can be happen in the future. Means if we are doing a particular contract, and for that contract I said that I'll already paid to the person, and in the basically he wants to return my money, but he did not return my money. But what he did, he gave his belongings to me, which I can sell out and return my money. So that contract becomes basically in the past. Means we the consideration already belongs to that person. If we just talk about the present thing, in the present thing, what we can do, we are doing a contract, I'll pay to the person, that person provides the terms and condition, whatever he just need to fulfill in a particular contract, that becomes the present. And if we just talk about the future thing, when we execute today a particular contract, but the consideration I can say that will give him or her in a future date. Means we perform a contract today, we execute a contract today, consideration for that thing will be will get by him in the future date. So that is basically a future consideration. Here is also a thing they explain to us. What is past consideration? Is something wholly done, foreborn and suffered before the making of the agreement. Then that means we already paid for a particular thing, but agreement happened in the future. Second thing, what is present consideration, which is simultaneously executed and consideration is giving on the same time. Future consideration, when the consideration is moved for the future date, and the contract performs before it, that is the future consideration. Our fourth point is consideration must be of some value. Here means that it is not the thing that check that just take my table or take my chair in the return of something else. That means if we just talk about a kind, means here there is a value for everything. So consideration also gives a value for a particular contract. If it is not valuable, that does not mean that does not fulfill. For example, if we are doing a business in India, that means we need to follow Indian rules and we need to follow Indian currency. But instead of doing that, what we are doing, we are using dollars, or we are using pounds instead of it. So nobody wants to basically do a business with us, because in so many things they will suffer from it, and they will that will be worthless for them. Or I can give you example, like we are doing a business, and I give you 1000 or rupee note, which is right now banned in India. So if we give that notes to the other party, that will become invalid contract. So our next point is consideration must be legal. Consideration has to be legal. There are different points also in which consideration has to be a legal thing. Consideration must move at the desire of the promisee. That means consideration comes from the promiser and no other person. Promiser has full rights to uh, whatever he wants to set for his particular contract. He has full authority. Whatever he desire, he can ask for it, but that will be valuable, not invaluable. Second point is consideration must be supplied by the promisee or any other person. Here means consideration supplied from promisee. That means the person who is accepting that contract, that consideration will be given by that person, no, not any other person. If somebody else is paying for it, that he has to notify it, or he has to told it to the promiser that particular person is gonna pay on my behalf. Consideration may be past, present, future, which we already studied, that consideration may be past, present, future. Fourth point is consideration must be of some value, which we already discussed, that the basically, if we just talk about the monetary terms, that monetary terms has to be real, not illusionary. If you just think that I can do a business with 1000 rupee note in India, so that is a illusory thing. Consideration must be legal. That means consideration has under all the rules and regulation which are told by the government, and has to be a desired amount. Means if there is a thing which is for 1000 rupees, that consideration can be 1100 or 1200, but that consideration, if you ask 10,000 rupees, the worth of the product is 1000, but they are asking 10,000, so that become void. So consideration must be legal. Now the topic is stranger to contract and stranger to consideration. There are two things. That means a stranger means the person whom we did not know, and the consideration which we did not know. So from this concept, what we are going to learn, that thing, the concept of stranger to consideration is valid and acceptable concept. Why is it acceptable? Because when we go in a market, we don't know that person, and we buy so many things from him or her, and we pay for that. We pay for that thing. Whatever is the money, we just paid it. So in that case, a stranger to consideration, that means we are not we did not know the money, we did not know the person, but we do a particular contract, we do a particular consideration, and we paid for it. For example, A, who is indebted to B, sell his property to C. C promises to pay off the debt of to B. In case C fails to pay, B has no right to sue C, being a stranger to contract. For example, there are two things. One is that you can do a contract or there is a consideration with a stranger. But in some cases, when two parties are already involved in in a particular contract, so only those two parties are liable for that contract and for consideration. If we just move that thing to the third party, that third party is not payable to that contract. Here are some exceptions for this. First point is beneficiary under trust or charge. Beneficiary under trust or charge means that beneficiary, if we just talk about the case study, Khwaja Muhammad versus Hussaini Begum. In this case, sued basically Hussaini Begum sued her father-in-law to recover rupees 15,000, being the area of allowance called kharchi kharchi pandan. Basically, there is a ritual in a thing that our father-in-law need to pay daily expenses to her daughter-in-law. So in that case, in that marriage, if they said that the consideration and the person to whom she married is a minor, and they both are minor for that time, so the promise is enforceable by Mr. H or by Hussaini Begum. In that case, basically, if you are beneficiary to a particular thing, that means you just need a benefit from that particular contract or particular thing, so you can charge or you can sue for that person. And if the government or any other person allow for that thing, so they can set to a particular party that you need to pay that thing. Second thing is marriage settlement. When we talk about marriage settlement, according to Hindu undivided family, or we can say that joint Hindu families, if there is any kind of partition happened between the male and the female, so male person has to pay alimony, which we know about the alimony, or which at the time of divorce we said that we use the term settlement, means all the expenses he has to bear, because at the time of marriage that person said to promise to her wife that all the for the whole life he is gonna manage her expenses. And now he or she is getting divorced, so what how she will how she will spend money, because she is married. So at that time the whole money is given to her by her husband for the whole life. So in that case, we are saying that we are talking about the point that stranger to a contract and stranger to consideration, means here a person is getting a divorce but he need to pay the all life expenses to that particular person. That becomes a contract, but there is no sense for it. Acknowledgement of liability or estoppel. Estoppel means basically the third party who is representing to the other party. In that case means, if somebody represent himself to the, like for example, there are four partners in a particular firm, A B C D, and there is a their best friend is E, Mr. E, and there every time Mr. E with A B C D in every contract, in every meeting there is E, but E is not a partner, but E takes contract on ABCD name and on their firm's name, and do something which is not correct or which is not lawful. So the person with whom he did wrong things, that person always blame to that firm, or file a case to that person, because they are not acknowledge that person, and they are not said that he is not a partner, or he is just our friend. They did not acknowledge for it. So because of that thing, The liability becomes comes on the firm or those partners, they have to fulfill it. Next is family settlement. Family settlement means settlement can be in writing when the persons who are basically separating, or they have multiple properties and which they need to or inherited property, we can say that. In that cases, family settlement comes arise, and that settlement has to be done with the parties, all the parties, all the family members. And that thing happen only if they have inherited property. If person is creating their own property, then there is no family settlement. Family settlement only happen when they have their inherited property. Next one is assignment of a contract. When there is a contract which is assigned only for the benefit to the person to whom we assign a contract, means to give them benefit, to give them rights, or to give them better thing. For that thing, if we do any kind of contract with consideration, that becomes valid. Now, our next topic is adequacy of consideration. Here means that a person needs to set a particular price or particular consideration which has to be adequate. Means, if I am saying that I want to sell my house, like if I just want to sell my house, and I said it to the person that I want to sell my house for rupees 1 crore. But if I just said 1 crore rupees, I just first need to check, is my house is worth it for 1 crore or not. If it is not worth it, that means my consideration is not a adequate consideration. So that becomes a invalid, or I can say that void contract. If I am asking for rupees 10 lakh rupees, and my that particular thing is actually worth for 10 lakh rupees, that's become a valid consideration. So it's not necessary that we are giving rights to the promisor, or he or she can ask anything for it. No, it's not possible. The consideration has to be adequate. If it is not adequate, that contract cannot be fulfilled. So according to Indian Contract Act section 25 explain this thing, and said that thing, that Indian Contract Act also states that an agreement to which the consent of the party is freely given is not void merely because the consideration is inadequate, but the inadequacy of the consideration may be taken into account by the court in determining the question whether the consent of the promisor was freely given or not. Here here it is also said that thing, that first we need to check our contract is valid or not. If our contract is not valid, that means we cannot able to do any contract. Means first we need to check the person from whom we are doing a contract, that person who is giving us a particular consideration, that consideration is also a free from his consent. If it is not is free from his consent, that consideration is also not a valid thing. Means you need to remember two things. First thing, the consideration has to be adequate in which terms? The worth of the thing, the worth of the particular promise or proposal which are proposing to the other party, it has to be worth it according to it. And second thing, the consideration is from a free promisor, because if we force promisor to fix a particular consideration which is not valid, that contract is also become voidable. And always remember this term quid pro quo. Quid pro quo means something in return, which is also written in the starting point. Next is legality of agreement without consideration, means if there is no consideration in a particular contract or particular agreement, so is it valid or is it not valid? It covers under section 10 that the elements of a particular valid contract, first we need to check the agreement is valid or not. Then according to section 25, there is a thing that declares contract without consideration as void, means if there is no consideration, we already read that thing, that if there is no consideration, then there is no contract. But in some cases we can say that if there is no consideration but the contract is enforceable by law. So we are gonna study about these points, that what are the circumstances or what are the points in which there is no consideration but still they are valid, a contract. First thing is that agreement in writing or registered. Basically, the agreement made Basically, the agreement made without consideration is valid if expressed in writing, means the promisor already expressed this thing in writing that he did not want any kind of consideration, so that becomes a valid contract. Second thing, that contract is also has to be registered, means that document or whatever that thing in which he write those sentences in which he said that he did not need any kind of consideration, that has to be are in a registered form. If there is any kind of contract which is made on account of natural love and affection, that means if a particular person or a particular human being made a contract out of natural love, means our parents did some kind of contract from their natural love and affection, our spouses did any kind of contract for natural love and affection in which there is no consideration and we did not validate that consideration because that thing is out of love and affection. Fourth point is between parties standing in a near relation to each other, like elder brother, elder sister, or a younger brother or younger sister, means the both the parties are in a close relationship. Natural love and affection is from their is the thing which comes from parents or which comes from a spouse. But if we said about the near relation, here near relation means brother and sister. So, in these points, if there is anything in writing and registered, if these things are, a person do a contract without consideration, but these documents has to be in written and registered, so it becomes a valid contract without consideration. Next thing is promise to compensate. If there is a person who promised made without consideration, means he already promised that in section 2(5) subsection 2 it defined that the promise to compensate wholly or in part. That means if a person is doing a particular contract in a whole or in part, but he promised that he compensate or without any consideration, or the person to be compensated has already done something voluntarily. That means we voluntarily said something that we did not want any kind of consideration, and in the replacement we did not want any kind of benefit. In that case, promise to compensate create and there is no consideration for a particular contract. Next is promise to pay a debt barred by limitation act. There is a act which is known as limitation act. In a law, limitation act provide us certain limitations of doing a particular contract or not. And there are so many contracts which are bound by time. That means if they happen in a particular time, it's okay, they can be executed, and if the time is over, they cannot be able to perform. So according to this, section 25 subsection 3 covers this thing. And what they said, that if that happen before, after the time has been passed, so we are not able to perform it. And what time is that? That period will be 3 years. If we do a particular contract, and it we are waiting from 3 years for a particular contract, and there is a time limit in a particular contract, so we are not going to perform it after 3 years has been passed, until unless a particular person uh, define his or her circumstances, that why she or he is not able to perform the contract. There are some points also. The promise is put into writing, obvious thing, which we in the first which we read in the first point also, that the promise has to be in writing, signed by the debtor or his agent. Both the parties, the person who is a debtor and the person who is agent, they both have to sign that particular contract. Relates to a debt which the creditor might have enforced payment of, but for the all of limitations. Means basically a person has to pay all the things in a particular limitation period. If that limitation period is crossed, so we cannot perform that contract. Next point is completed gift. Completed gifts means, uh, if we if some person give us any kind of gift out of natural love, affection, or there is a near relation, so that gifts are consideration free. There is no consideration for it. Means if some person gives us a gift, we did not give in return anything. Agency is a thing that a particular agency is not like a travel agency kind of thing here. Agency means principal agent. That means a person who is doing work for his principal. That means, for it's like employer and employee. Employer is known as principal and employee is known as agent. When a employer is very happy from the work of employee, and he gives any kind of reward to his employee, so that becomes a contract but without any return, so there is no consideration in it, but that also becomes a valid contract. Next one is charity. Whatever we basically do, any kind of charity. So basically, whatever we do, any kind of charity to the person, to anything out of faith or something like that, so that also become valid. And because there is no consideration in it, we are not gonna get anything in return, but still we do things for charity, so that also a valid contract. Now, if we just sum up with the agreement without consideration, there are basically you can read only these 6 points instead of the whole theory in it. Or from examples you can understand it in a more better way. So if you just read these 6 points, you are able to understand what I already told you. Next point is legality of object and consideration. Legality of object and consideration means the thing, the contract, the basically the object of a particular contract has to be valid, and that consideration is also has to be valid, or the object of that particular consideration is also a valid thing. Basically, the word object and consideration here mean the same thing. That means we just need to follow all the rules, all the things according to law. We need to decide our consideration. If it is forbidden by law, a particular object or a consideration in a particular agreement, so we are not gonna perform it. That becomes our void contract, or I can say that void agreement. Second point, if it defeats the provision of any law, that means if that particular thing did not follow the provisions of any law, or it becomes a problem for a contract if the consideration is not under the law terms and conditions. Next, if it is fraudulent, means we are doing a contract but the consideration what we are saying that is fraud. That means we also discussed about fraud in the last lecture, that if we are considering, or we are a person who is illiterate and he did not know any kind of thing, and we are just saying him, no, no, your property is for rupees 1 crore, and just give us the papers of your property and we give you 1 crore. So that means we are defrauding that person, and that consideration is also a fraudulent thing, which is not correct. Next is, if any kind of property, any kind of person is belong to the other person, but we are gonna do a contract for that person for that property, which also become a void thing. If there is any kind of injury happened to that person or that property, means if we are doing a particular contract, so what we explain in our contract, the property, the person has to be in the same way, uh, uh, which is described in a particular contract. Next, if the code regards it is immoral or opposed to public policy, means if it is harmful to public or it is immoral according to society, that consideration will also denied and that contract becomes illegal. If we talk about partial illegality, partial illegality means the contract is, some part of a contract is valid and some part of the contract is not valid, or I can say some part, some object of a consideration is valid and some object of the consideration is not valid. So partially, if it is illegal, so we cannot, the partial thing we can perform it, or we can do a proper settlement for that thing, that it is not totally valid. So we are gonna do any kind of settlement in it. We just did we perform half, we can say that we perform half of the contract, or we perform half of the agreement in it. So there is a mutual understanding of both the parties, that they want to perform a partial contract or agreement, or they want a compensation, or they want to rescind the contract. That means they want to finish the contract. Next is agreement opposed to public policy. What are the agreements which are opposed to a public policy? Here are some headings for it in which we can understood in a more better way. Trading with enemy, if any kind of person who is enemy to our country and we are doing a particular contract with consideration to that person or that company, so that will become against the law or against our public policy. We are not able to pursue it, or we are not able to fulfill that contract. Second is agreement to stifling prosecution. Here, a stifling prosecution means if we are basically helping to the person who is under the criminal charges, which is already a offense to the public nature, if we are doing a particular contract to that person, that also become a void contract. Next is contract in the nature of camperty and maintenance, means if we are providing something to that person, we are giving any kind of here maintenance means promotion of litigation in which a person has no interest of his own. Here champerty is a bargain whereby one party is to assist another in recovering property, or in return is to share in the process of action. For example, we can understand it in a way that basically we are doing a particular thing in which we are not even interested, or we are bargaining for the third party which we are not belongs to that property, but we are bargaining for it. So both the things are not under the law, and both the things said that our contract becomes void. Next one is agreement for the sale of public offices and titles. Means if we are doing any kind of contract or any kind of agreement in which there are public offices and titles are there, which are against the rules of a government, because we cannot sell public offices and titles. If we are doing that, means we are doing a fraud. Here is agreement in restraint of parental right. Parental right are those rights which are explained already for in a guardianship. Basically, there are some rights inherited to our parents which we nobody can change and nobody can pursue instead of parents. Means if we are doing any kind of agreement to stop the rights of any parent, that becomes a void contract. Agreement in restraint of marriage, if any person said to the other person that no, you are not going to marry that person, only it is happened when the person is a minor. Otherwise all the agreements which are doing for a marriage are valid, but if the person is minor, that becomes void. Marriage brokerage or brokerage contracts, basically the contract which are which are with the brokerages, whether it's for marriage or whether it's for any kind of contract, and we are doing that thing for the dowry or for unlawful thing, that also becomes a void. We are not gonna charge any kind of brokerage for it, or if we are charging it, that becomes a void contract. Agreement in restraint of legal proceeding, if we are talking about legal proceeding, we are doing any kind of legal proceeding, and we any person is stopping us by doing that, that agreement is also becomes a void agreement, because no person can do or can stop any person from doing any legal proceeding. If any person is doing any illegal thing, so there are all the rights to stop that person, but if a person is doing a legal proceeding, so nobody can stop that person. Next is agreement interfering with course of justice. Same thing. If there is already a course of justice is happening, and any person is interfering it or try to stop it, that also becomes a void agreement. Next is agreement in restraint of trade. If we are doing a lawful trading or we are doing a lawful business, so nobody is able to stop us, because we are particularly doing all the right things. We are not doing any kind of wrong thing. Next is agreement tending to create monopolies. Monopoly is the thing in which there is a group of if we just talk about market, then there is a group of companies, group of firms which create monopoly. That means they are the only who is gonna supply to the consumer, and the consumer has to purchase from that whatever prices they fixed, whatever prices they charge. They create monopoly, which is also abolished from the uh, law. And there is a consumer protection act also, in which Monopolies is restricted for the market. Next one is restrain agreement in restraint of personal liberty. Means if there is any kind of restraining, means somebody is stopping of personal liberty, or somebody is saying that the person, somebody is restrict the personal freedom of a person, that also become a void or illegal and against the public policy. Means nobody can stop anybody from doing anything which is personal. Here it is, our fifth unit is ended. If you have any query regarding it, so you can ask me now.
Yes, can I ask my question?
Yes, you
Uh,
may.
Yes, thank you so much for this explanation, which is very helpful for us. My question is about the completed gifts, because you mentioned it. In fact, what I'm seeing in Madagascar, in my country, is that, for example, the World Bank is giving some cars to an NGO, but at the same time, the donor gives the rules for the use. And I do not understand clearly what type of contract exists between the donors and the receivers in this case, because as you mentioned, completed gifts, we don't there is no rule after after that we receive the gift.
See, here we are talking about the consideration. Consideration is the thing when we get something in return, because we are doing a contract which we need something in return, some kind of benefit or some kind of monetary thing. If we are talking about the gifts and we are talking about charity, there is also a kind of contract in it, because there are two parties. One is giving the gift and one is receiving the gift, but in return one party is getting a gift, other party is not getting anything from it. Okay, so basically, if
Okay,
we just talk about gift or if we talk about charity, that means both the parties are one is giving and one is receiving, but it is out of consideration. There is no consideration is in it. One is receiving, but the one is not getting any kind of benefit in it. So that's why we are saying that there is no there is a contract parties, but there is no consideration, but again it is legal. But because we what this act said, that if there there is no contract, but in these cases it is a contract or a agreement, because one is receiving and one is giving. There is a proposal and a acceptance, but there is no consideration in it, but still it is a valid thing. They are explaining it this thing. Now is it clear?
okay. Yeah, it's clear now. Thank you so much.
So let's we start our next unit. Give me a minute. So now Next unit is void agreement and contingent contract.
Excuse me, are you speaking, ma?
Yeah, her mic is mute.
Ah, okay.
Anything problem? So basically, when we talk about void agreement, the when we talk about contract, becoming a contract, our all the proposals are the first became the agreement. Then when they are enforceable by law and they can be executed, they become contract. So void agreements are the agreements only because they are not gonna fulfill it, or we are not able to pursue them, or we are not able to execute them. That why they are just a agreement and they did not become a contract. Just give me a minute. Sorry for the interruption. Basically, we are talking about the void agreement. Now, when we talk about the void agreement, these are the agreement which became the agreement. The person basically propose the sorry a promiser propose a thing to the acceptor, but they did not fulfill it because of some kind of problems or some kind of unlawful thing. That's why they become only a void agreement. When we talk about void agreements, it covers under section 2G of the Indian Contract Act. When we just when you see, you can see that 2 is out of bracket and G in a bracket. That means there is a part, or there is a part of section 2, different parts like A, B, C, D, then it is covers under section 2 subsection G actually. So basically, the agreement which is not enforceable by law, that means we make a agreement, we make a proposal, the other person may be accepted or maybe not accepted, but that agreement is not enforceable by law, so that becomes the void agreement. It is also known as void ab initio. It also asked many times in a paper about the void ab initio. So you just need to remember that void ab initio means the thing or agreement which is unenforceable right from the time they are made. Means when you make the contract, that becomes already that means unenforceable when you think about, actually when you propose that thing to the other person, that becomes unenforceable. For example, if we are doing any kind of act or agreement with minor or the person who is unsound mind, which we read in the last session also, that the agreement with the minor or the person of unsound mind, we cannot do a contract with that person. So if it is already mentioned that we are not able to do a particular agreement or contract with minor or person of unsound mind, and we are doing it when we know it and still we are doing it, so that becomes a void ab initio basically. So basically when we talk about the contract, these agreement never become a contract at all because they are unenforceable by law. And when we talk about contracts are only can be fulfilled and can be executed when they are enforceable by law. So if they are unenforceable by law, they are void agreement, or we can call them void contract. So here are some types of agreement have expressly declared void under the various section of the Indian Contract Act. When the agreement by or with person incompetent to contract, which comes under section 10 and 11, means if there is a person who is not competent to the contract, means who is not able to understand the contract and who is not able to fulfill that contract, and we know it, but still we are doing a particular contract or agreement with that person, so that agreement becomes void agreement. Second, agreement entered into through a mutual mistake of fact between the parties. We already read about the mistake of fact in the last session, if you remember. So basically when we both the parties, we both know that there are facts which are there is a mistake in those facts, but still we are pursuing that agreement, both instead of correct them, but we are doing them, which is harmful, maybe harmful to the society or maybe harmful to any other person, still we are doing that, so that agreement becomes void agreement. Third one is agreement, the object or consideration is unlawful, which we already read in the fifth unit, that if there is a consideration which is not adequate, if that contract worth for rupees 80,000 rupees and we are asking for 10 lakh rupees, so there is a huge difference, that consideration or the object of the agreement is not valid, so it become unlawful. Next, agreement, the consideration or object of which is partly unlawful, means any kind of consideration or object which is in the fourth point, sorry, in the third point, the whole object or the whole consideration is unlawful, but in the fourth point we are saying that particular part of the contract or a agreement is unlawful. So first we need to check, can we execute the rest of the which is lawful contract or agreement, can we execute that thing? If we can execute that thing, so we execute the partly contract which is lawful and we rescind the contract which is unlawful, or we can rescind the whole contract, or we can make the whole contract lawful. There is a choice between both the parties, but the contract or agreement has to be lawful when executed. If it is unlawful, so that particular part or the whole contract becomes void. Next, agreement made without consideration. There are, we already read in the last unit that there are so many agreements in which there is no consideration, but still they are valid because they can be performated, they can be from out of natural love, affection, or these kind of contracts. Next is agreement in restraint of marriage, means if there is a minor person and forcefully actually in India there is a ritual in which uh, already marriage of a minors happened a lot of years back actually, but still in some places marriage of a minors is actually some people believe in that system and they are following it, but actually it is not a right thing. A minor cannot be a marriage. So if they are restraining from that marriage, then it's okay. If they are forcefully doing any kind of marriage with minor, that agreement has become a void agreement. If there is a trade which is not be able to fulfill, that means we are doing a trade which is unlawful, that we cannot do. If we are restraining from legal proceeding, means we are creating any kind of problem in the legal proceeding, that also become void. Uncertain agreements means the certainty of happening of a particular agreement or a particular event we are not known about it, that also becomes a void. Wagering agreement, when we basically it's like when we bet with someone, like happening of this contract is gonna be, I'm gonna pay you this thing, if it happen like this, I'm gonna pay you this. So these kind of agreements are also void agreements. Impossible agreements, the agreement which are not able to perform or which are not able to fulfill or executed, they are impossible agreement. Explanation also, they said to us that 1 to 5 we already uh, cover from unit 3 to 5, and now we are going to read 6 to 11 point actually thoroughly. So our 6 point is agreement in restraint of marriage. When we talk about restraint of marriage, it covers under section 26 of the Indian Contract Act. There is a agreement between the persons other than minor. Basically, there is a agreement between the persons other than minor is void. Means basically, if you are doing any kind of marriage with a minor person, that become a void thing, that is not completed, that and that cannot be executed. When we talk about agreement in restraint of trade, means we need to trade with our law, and we need to trade with in the circumstances or with the situations which are need to be followed by the law. If we are not following it, if we are not completing it, we cannot do any kind of agreement with it. If we are doing it, then it becomes void. Here, courts therefore do not follow any tendency to impose restriction upon the liberty of an individual to carry on any business, profession, or trade. Means a court cannot able to impose any kind of restriction until unless they carry a business which is not uh, basically lawful. There are exceptions also. If basically, there are two exceptions here. First is those created by statutes or those arising from judicial interpretation. When we talk about statutory exceptions means sale of goodwill. Goodwill is a thing which we make, like we just follow brand name. We did not follow quality. We never go through price range. If there is a particular name of a brand, so we just thought in our mind that that product will be good, that prices will be fair enough for us. So when we talk about the goodwill, and in the business, there is a process when you can sell your goodwill or you can purchase your goodwill, but there is a limit for it. And basically, if there, you can understand from the example that there is a person doing there are three partners ABC in a particular business, and they are using a particular name which the people aware of it. And if we just talk about that particular these three partners, one partner retire from the firm or one partner voluntarily just out from that firm, and after that he open his company or firm with the same name, with the same business, and he just take all the customers with him. It is unlawful according to our business law. Means you cannot pursue the same thing from which you just basically learn, or you just make different locals from it. So there is a sale of goodwill is also a thing, is a exception. If any person did that, that will be not acceptable. Next is certain restraint in partnership, which I already told you that there is some rules which are followed in a particular partnership. So they have to fulfill it and they have to follow it. And all the partners at the time of whether it is dissolution, whether it is sale of goodwill, whether it is basically profits taking, they carry each and everything in a partnership way. And according to Indian Partnership Act 1932, if they are doing it accordingly, so they can perform all the agreement and all the contracts. Next one is under judicial interpretation. When we talk about under judicial interpretation, it covers under section 27 of the Indian Contract Act. Next one is trade combination. First one is actually trade combination. The idea of regulating business and not restraining it have been held to be desirable in public interest, basically. So when we talk about the business combination, that means the whole idea of a particular person, but the other person if know that idea, and he just uh, theft it, or he just open his own business regarding it, that trade combinations are also not acceptable. And the person who have the idea, they can patent it and they can just name it on their own name with a certain fees. Next one is exclusive dealing agreement. There are some kind of agreements which are we can say exclusive dealing, means only a particular firm or only a particular person can pursue it. If it is doing with the under the law, they are valid. And if you are, if there is any kind of unlawful thing is added in it, that will be not acceptable. Some are service agreement. Service agreements are those agreement in which service is provided from a particular thing. That means a person is just providing a service and not the whole contract. And we are not trading goods here, we are just providing service. For example, right now I am teaching you, I am providing you service, I am not giving you any kind of good or anything else, I am just providing service to you. And if there is any kind of mishappening over there, or if there is any kind of service which mention in a particular agreement, but they are not following it according to the agreement, so that becomes unlawful. If they are agreeing on a particular terms and condition, they have to be stick on it, and they have to follow those rules in which are told about the service agreement. If they are actually just like a goods agreement, whatever we are talking about consideration, whatever we are talking about business, service business is just like same as the any other business. In service business, we are just providing services, not the particular goods. Actually, that is the minor difference. Otherwise all the things are same. Here are some activities which you can uh, basically check your progress in this. According to it, I must say that you should read at your home. Agreement, next point is agreement in restraint of legal proceeding, which we already discussed. When what is legal proceeding? When we are doing anything according to Indian Contract Act, and we are basically doing things according to the whole procedure which described in the Indian Contract Act, but there is any kind of agreement which is restraining to perform legal proceeding, it means that proceeding will is not gonna be happen because of that agreement. which what is our first point is restriction on legal proceeding. Means there is a party who is enforcing his legal rights under any kind of respect on a particular contract, which is actually uh, basically harmful for any legal proceeding in a ordinary tribunal. So basically, if a party is restricted from doing any legal rights or performing any legal rights, that becomes a void thing. You cannot, according to Indian Contract Act, said to any person that a person is not able to uh, proceed his legal rights. Second one is limitation of time. In every particular agreement or in any particular right, a limitation of time is very important factor, because we always do a agreement or contract in a particular limited time. If we propose a contract some in front of some party, and that party did not respond us in a certain time, then we propose that contract to some other party. And basically going on the whole process. Means if we are doing a particular contract and we are saying that we will perform it in a some better way, or in on future date, I can say that that future date has to be decided. What will be the future date, how we can perform it, how we can execute it. So if we just talk about that, for example, the limitation period said we can wait for the 3 years to execute a particular contract, and if that 3 years will be passed, the other party can sue that person of not performing it. And if this time limit can be different for the different contract, it can be 6 months, it can be 1 month, it can be 1 year, or it can be 3 year. Maximum it is for 3 years actually. Okay, so it is variable according to the contract or according to the agreement. So if that contract, that agreement is not gonna fulfill in that particular time period, so that becomes void, and that cannot be executed after that particular time. Now, what is uncertain agreement? Uncertain agreement means the possibility of that agreement is not certain. Means it cannot be happened, it can be happened or it cannot be happened. It covers under section 29, and such kind of agreement declare actually void. Means if I just said that today is gonna be rain, and if it is today gonna be rain, then I'll do this work. And if today is not gonna rain, I'm not gonna doing this work. So basically what I am doing is I am depending on some uncertain thing. So when we are doing any kind of agreement which is uncertain, so when it is not certain, we are not sure about it, so we are not able to agreement on it, because there are two parties in a particular contract. Maybe I am okay with the uncertainty and the other party is not okay with the uncertainty. So these kind of contracts are declared void, and you cannot I'll read one for you. Agreement have to be held not to be certain. Means the thing which a person cannot be uncertain, or a agreement cannot be uncertain. Mr. A, who is a dealer in coconut oil, only agrees to sell to B 100 tons of oil. That means Mr. A is agreed to sell to Mr. B only. The nature of Mr. A trade indicates the meaning of the words, and A has entered into a contract for the sale of 100 tons of coconut oil. So there are means it is only a oral contract, and it is not a basically a written contract, and it's only on the words about the 100 turn and not on the anything else. So basically when it's just only on the words, so it maybe happen and maybe the person did not execute it, and we have no proof of it, and we cannot basically uh, force that person to pursue that agreement. Next one is wagering agreement. Now, what is wagering agreement? Wagering agreement is a contract. Wagering agreement is an agreement under which money or money worth is payable by one person to another on the happening or non-happening of a future uncertain event. It is just like a uncertain agreement. When we just talk about the uncertain event, that means कि basically it can be happened and it cannot be happened. So when we just talk about uncertainty, it also comes under the wagering. Wagering agreement includes the consideration also, and that consideration with the large amount and not with the lower amount. Here are some essentials of the wagering agreement. What are the essentials of wagering agreement? First is uncertain event. The first point of a particular wagering event is that event may be happened and may not be happened. Second is mutual chances of gain or loss. Means the person is can be gained from that particular agreement, or cannot be gain from that particular agreement. That can be a heavy losses also in these kind of agreements. They are actually basically a speculative agreements in which only gamblers and gangs actually, or we can say that betting kind of thing happen. In that cases, they are that kind of agreement actually. In the real world, normal human beings cannot uh, uh, basically agree on these agreements. When we said about mutual chances of gain or losses, so mutual chances basically can be in our favor or cannot be in our favor. Next point is neither party to have control over the event. Basically, if there is a event which can be happen and which cannot be happen, so no party has control over it. Next is no other interest in the event. Basically, the only interest is it's one will someone win or someone lose. About It's all about the particular event, and it's all about the consideration. Nothing is meaningful in these kind of events, and nothing is permanent in these kind of agreement. Next is promise to pay money or money's worth. Basically, it is just a promise to pay a certain money. If it happened, so I'm gonna pay you this. If it is not gonna happen, you're gonna pay this thing to me. So basically it's all about the money or money worth. Next is effects of wagering agreement. What is gonna be effect of a particular wagering event? Effects of a particular wagering agreement covers under section 30, which said that the agreement becomes void and it cannot be able to perform it, because if we execute it, and if we did not restrict it, or we said it will be legalized, then there are n number of people who are gonna be in losses. Then uh, there is multiple problems also created, because if a person go in a loss, they their families will suffer. They are gonna do, some people maybe suicide, and so that's why our government, or our Indian law said these kind of agreements will not be able to fulfill, and they are actually basically not legally accepted. Next thing is lotteries. Lotteries is also a same thing. We all know about the lottery system. In a lottery system, when we draw a certain chit or we draw something like that from a particular thing, that also a kind of wagering agreement. Maybe that slip is for our name, or maybe that slip is not for our name. So that one is also not authorized by government, and actually it is a punishable offense, and if somebody is doing that, so it can be punished for he or she can be punished for imprisonment, which can be extended to 6 months, or fine also. Here are some case studies which you can read out, and if there is any problem in these cases, you can ask me in the next session. So there are some exception to wagering agreements. Basically, we said that thing, that wagering agreements cannot be able to perform, or we cannot able to execute, but there are some exceptions. Here, what are the exception? First one is transaction for the sale and purchase of stock and shares, or the sale and delivery of goods with a clear intention to give and take delivery of share or goods, or the case may be. Basically, when we talk about shares and when we talk about stocks, we just purchase share, and there is a, if its price goes high, then we are gonna sell it. Its price goes down, we uh, we go in a loss. So particularly, basically, it is also a kind of uncertainty when we just purchase a share, but it is also an uncertain condition. It can maybe give us profit, and it can maybe give us loss, but it is authorized by the government that you can do purchase of share, and you can sell the share, means you can do a trading in a particular share and a stocks. So that's why it is exception to wagering agreement. It is a uncertain event, but still our government make it legalize. Second thing is prize competition, which are games of skill like pictures or crossword puzzles, athletic competitors. In this thing, basically the prize competitions also depends on uncertainty, who is gonna win that particular show or particular event, or who is not gonna win that thing. That also there is also winning prizes also. If you just watch TV, there are multiple singing shows, dance shows, in which there is a prize money also. It's like in India, it's like KBC, Kaun Banega Crorepati, also, in which there is a prize money also. So it's all on uncertainty, and these contracts are wagering agreements actually, but still government said them legalized. That's why we are pursuing it and we are doing it. Next one is agreement to contribute to a plate or prize of the value of our rupees 500 to be awarded to the winner of a horse race. Basically, when we talk about horse race is also actually banned according to law, and we cannot basically use that thing. But if we talk about the contribution to a particular price of the value for that, so we can do it. Next one is contract for insurance. When we talk about insurance policies and we are paying it, we all have insurance policies, policies, and we are paying premiums. It is also a wagering agreement, because we are paying premium for particular insurance, but it can be basically, it is also an event of uncertainty. If I just took a car insurance and I am waiting when gonna my car is gonna crash, then I am able to claim insurance. So that is a event, can be certain and can be uncertain. So when we don't know about the certainty, but still we are doing it, so that one is also a exception for this act. Next one is agreement to do impossible acts. Impossible acts like I am saying you that I am gonna take your class from moon. So that is a impossible act actually, and there are some contracts or some agreements like we already studied that we cannot deal with, for the public offices or the public titles or officers titles. We cannot deal on their name. These all are actually comes under impossible act, the act which is not gonna happen and which cannot be able to perform, which cannot be executed in any circumstances. That agreement is a impossible act, and that covers under section 56 of the Indian Contract Act. Next is restitution. Now restitution, what it means? Restitution means something in return, sorry, means only return, not something in return. Or restoration means we restore something. When an agreement or a contract becomes void, the person who has received or benefit or advantage such agreement or contract must restore it or compensate for it to the person from whom he has received. Means if there is a void agreement and any person get benefit from that agreement, means one party get benefited from that agreement but there is a loss from the other party, and that agreement is a void agreement. So it is the responsibility of the person who get benefit give compensation to the other party, because it is a void agreement for both the parties, not only for the one party. That means whatever benefit, whatever advantage is uh, come with the other party has to be shared with the other party. Means they have to restore it, whatever compensation a person get, and it covers under section 65 of the Indian Contract Act. Next one is contingent contract. Contingent contract is also a contract when we are gonna wait to do or not to do something. When there is a contract to do or not to do something, if some event is gonna happen and is not gonna happen. For example, a contract to pay Mr. B rupees 10,000, and if B house is burned, means I am gonna pay you rupees 10,000 if somebody's house is gonna burn. That that is a very weird thing actually, but this thing is a contingent contract when uh, we are waiting something to be happened and not to happen, and we are actually discussing over a particular price. There are some essential features of a contingent contract. What they are, first thing is that it is dependent of happening or non happening of some event. Second thing is an event is collateral to the contract, means that event should be focused on that contract, particularly the main, actually the object of that contract. Next point is a contingent event should not be mere will be of the promiser. That means कि that one not only for the promiser but for both the parties, not only for the single party. Next, there are some rules regarding enforcement of a contingent contract, and these cover under section 32 to 36. First is contract contingent happening of a future's uncertain event. They can be happened and they cannot be happened. They actually they all agreement are same. Uncertain event, wagering agreement, and this impossible act, contingent event, they all are actually depending on uncertainty and uncertainty of future. Second point is non-happening of certain event can be enforced when the happening of that event become impossible. Obvious point is that if it become impossible, then the thing which is we actually we can execute only the second part, that which is not going to be performed. Next one is if the contract is contingent upon as a how a person will be unspecified that time, means a person is not specified that time, that person will also become that contract will also become impossible. Next one is contract contingent upon the happening of an uncertain specified event within a fixed time. Means you should be respond in a fixed time. If you just think that it can be for unnecessary time, or for the long time, it cannot be gonna happen. Next, that contract, particularly if it is expired and it is not gonna be happened, so that agreement is also expired. If the time period is expired of that uncertainty, so that contract is also be expired. Contingent agreement is actually is only the thing which we are saying that to do or not to do anything. If it is impossible event, then it becomes a void, and that impossibility of that particular event, it can be known by the parties and unknown by the parties. If it is known by the parties, then it is their issue actually, because they are depending on that thing, and they are just wasting their both the parties time. And if they are not knowing that, so whenever they get to know, they will finish that contract. So this is the all your sixth unit actually. So your block two units we studied today. If there is any query for it, you can ask me. Is there any query for it?
From my side, no.
Okay. So my suggestion actually to you is that please try to read these things out for your exam point of view. And if you have any problem with it, so you can discuss it in any session.
Okay, well received. And thank you so much.
You're welcome. Thank you.
Okay, bye.
Bye.